That's kind of like going to a Mercedes dealership. I want the new Mercedes. Well, look, I already have a transmission from my Honda, and I've got a braking system from this Toyota. Put them in. I don't need the transmission and the braking system from the Mercedes. Hi, Jeff Marsace, the Plain English Attorney, and now we're going to get into the fifth module, which is the overview of how we actually get to do this in-law protection planning, which also has a lot of other benefits that go along with it too for the next generation. All right, so how is all of this coming together in protecting assets for the next generation? So I'm still going to talk in terms of John and Jane Doe doing their planning to protect their three kids, Jennifer, Jefferson, and Jim Doe, and how it all kind of comes together. Now, these are part of an overall strategy. So these things are mandatory. So now I'm adding right here, this is the plan, and you will have a place to actually download it and print it out if it helps you follow along better. Right, so the main thing is we need a revocable living trust as the keystone. This is where your plan is put into place in a way that's going to avoid probate, avoid a lot of other vulnerabilities, including costs for probate and related things, delays in estates being settled, things being more open to being contested, and a loss of privacy for exactly what's going on in the estate. Now, I've got my own estate crash course, which I'm going to be putting a couple of elements in with here. It's not the full course, but it's going to be enough pieces that you can look into the revocable living trust and what it actually is doing in more detail than I'll go into in these specific modules for this in-law protection planning, but it's going to be kind of added as bonus material so you can get a little bit better understanding. So if you want to know more, then go ahead and get the estate crash course. And we're probably going to offer this as a kind of bundle thing as well, but you'll at least get enough on the different documents. So there's that revocable living trust as where the plan is put into place. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. All right. So the next piece of it, and this is the part that's going to protect the money long term for the kids, for the rest of their lives. It's asset management trusts. Now, asset management trust, this is how it's branded by a company I do a lot of work with, and there's professionals that's all part of a network. It's called the Estate Planning Source. They call it an asset management trust. I've kind of been using the shorthand of a beneficiary trust in my practice, but really, if you're familiar with the documents from the Estate Planning Source, I am talking about the asset management trust, even if I had branded it as a beneficiary trust in the past. It's not what the Estate Planning Source calls a beneficiary trust. I like things to be locked up more solidly, and so even if I end up referring to it by accident somewhere in here as a beneficiary trust, no, I mean the asset management trust. And that's what my clients have gotten when they've done this type of planning. They've gotten the asset management trust, even if I called it by something different. So what this does is it receives the money from the revocable living trust. So the asset management trust is where Jennifer Doe, Jefferson Doe, and Jim Doe get their money locked up in trust for their benefit throughout their lifetime in the hands of a separate trustee in order to keep it protected. Now, I'll go more into exactly how that works with the specific module on asset management trusts. So it's the revocable trust that determines what goes into those asset management trusts. So through this example, we've used it as equally to Jennifer, Jefferson, and Jim, and that's what most of my clients do, but it doesn't have to be that way. it can be 40, 40, 20. We don't have to change anything in the asset management trusts. We have to change that in the revocable trust that it's a 40, 40, 20 split. So this is where the direction of where the money goes. Maybe, and sometimes my clients do this, they don't want it a third, and a third. They want 30, 30, 30, and they want 10% to go to charity. Well, okay, that's in the revocable trust. Nothing in the asset management trust. Think of it as your car is at the gas tank, and the tank can take 13 gallons and it's on empty. Well, you can decide to only put 10 gallons of gas in one car, but fill up another car. None of that has anything to do with the actual gas tank. So again, we don't have to change anything in the asset management trusts to reflect a different kind of beneficiary breakdown of how you want things to go. So that's the revocable trust going into the asset management trust. Now, here's where sometimes my clients start saying, well, do we really need an asset management trust for all three of the kids? There's only one that we're really concerned about. Look, believe me, as someone who has been doing this for more than 25 years, you're going to set up nothing but family strife among your kids if one of them is going to end up having their inheritance tied up and the others aren't. Exception to that, if it's like a special needs beneficiary, there's already disability or some other reason for it. Yeah, but you don't want to say, well, look, Jefferson is with Becky and we just don't trust Becky, so we're only putting Jefferson's share into an asset management trust. That's not going to fly. That's going to create huge issues with the kids after you're gone. All right. Well, can't we just all put it into one trust, one asset management trust for all three kids? Well, no. And here's why. It ends up overcomplicating things. And if it's in one trust and one kid wants some money and the trustee says, yeah, that's for a good cause. I need $10,000 because I need it even as a loan, not a distribution, so that I can expand the marketing for my business. We're anticipating making back 4 or 5 times as much with this marketing campaign within a year, and we'll pay you back. Oh, great, here's $10,000. One of the other kids and their spouse is yelling and screaming, well, they got $10,000. Why can't I get $10,000? I wanted to take a vacation. Well, it's not the same thing. But because it's coming out of one trust, it just creates more arguments. Now, the way I do this in my law firm, we're going to set up the asset management trust as one for each kid. That's it. That's the way we're going to do it. If somewhere down the line you decide to make it unequal, or, well, we're leaving this to one kid directly and we're not going to ignore their asset management trust, look, fine. I'd counsel against it, but we're going to set up this asset management trust as one for each child, kind of across the board. That's the way it is. So now let's talk about the next issue, which is, well, in this design, you're not showing the tax deferred money going into the asset management trusts. That's correct. That's because tax deferred money for tax reasons has to have some special considerations that are in IRA trusts, but not in the asset management trusts. Again, it becomes too confusing to try to put them both together. So we do one IRA trust for each child. So now with John and Jane Doe, when they're setting this up, they name each other as the primary beneficiaries in all their IRAs, 401ks, Roths, whatever, tax-deferred, tax-free accounts. They're each other first. And then the contingent beneficiary is equally among those 3 IRA trusts. Now, the IRA trusts, We're going to have a separate module. I'll go more in depth, but they've got all of the same kind of protective provisions as the asset management trust, but it's got the tax language to make sure that the trustee can control the money that comes out of the tax deferred status, gets taxed, and then is reinvested. The trustee is still in charge of that, but now they have a 10-year period to pull that money out instead of it having to happen all at once, or, hey, you get a good accountant, maybe they can spread it out over 5 years, but it ends up staying protected. And what usually happens, and it's recommended in the way I drafted it, goes into the documents, once that tax deferred or that tax free period ends, well then Jefferson's protected money in the IRA trust, because it no longer needs the tax issues, that can go into his asset management trust. Same thing with Jennifer, same thing with Jim. So these are anticipated to last 10 years after John and Jane Doe have passed on, and now it can be combined with what's in the asset management trust, which is going to be there for the rest of their lives. So that's the way, and again, I'll go over more of that in the separate module on IRA trusts. And then there's the, quote, ancillary documents. And I just use this because this is the stuff that really kind of needs to be in every estate plan, plus a few more items that just needs to be with a revocable living trust. So what we're really talking about, what I call the big five. These are the basics. Even if you're just doing a simple will plan, well, okay, you need a durable general power of attorney. Who's the person legally making financial decisions for you if you become incapacitated? Well, that's the durable general power of attorney. Who's making healthcare decisions for you if you're unable to make those yourself? All right, that's the healthcare power of attorney. So we have, again, people listed in order. Then we also have the living will. In North Carolina, it's a declaration of a desire for a natural death. It might be called other things in other states, but basically, it's if I reach the point where the doctors don't think there's anything they can do, and I'm, quote, terminal and incurable, I'm in a persistent vegetative state, can they or should they withdraw life support? So it's really at the point the doctors would say, well, there's nothing we can do, they're going to turn to the family. Well, no, you've got your document there, that living will that says, here's what I want, so that that burden of the decision doesn't end up on the family or anybody else. Then there's also the nomination of conservator document. This is who would be a conservator for you if someone was going to go to court and say, I want to be assigned guardian. Well, okay, this document is there to list the people you want. And the good thing about North Carolina specifically, and other states are going to vary, North Carolina lets you name a conservator of the person who's making your health care and living arrangements, and a conservator of the estate, which is who's handling the money. They can be separate lists of people. And that kind of lines up a lot with the planning that we do. And then there's a will. Well, if you're doing the simple will, your will is where everything goes. When you're working with a revocable living trust, and in this same protection planning setup, the will just says if anything does end up in probate, it gets sent over to the revocable living trust to be distributed with everything else. So it's a very simple thing. So those are the 5 main ancillary documents. Now, in the kind of, quote, bonus materials that are from the estate crash course, it's not the full course. It's a couple of those modules. We're going to go over exactly what's in that, what I call often the toolbox, for the revocable living trust, so you can get more detail on those items in those bonus materials for this program. But those are really the ancillary documents we're talking about for John and Jane Doe. So that's the overall plan. Just a couple of words. Look, this is a complete system. It's not, well, an a la carte thing. Well, I just want one asset management trust. I already talked about the issues with that. Or, well, I already have a will. Or I already have a revocable living trust. Well, no, you don't want to do that. That's kind of like going to a Mercedes dealership. I want the new Mercedes. Okay, we've got a Mercedes. Here it is. Well, look, I already have a transmission from my Honda, and I've got a braking system from this Toyota. Put them in. I don't need the transmission and the braking system from the Mercedes. It's never going to work right. It's just not. So you're looking at putting together the complete system so it's integrated. And it definitely is integrated. I once had a client, and this ended up being a big issue. She didn't do the planning with us because she had done a durable general power of attorney and nothing else with another attorney. And I said, look, we have to just redo it so that I know what's in it. I know that it's complete. I thought, well, that's just a waste. And she just ended up not doing anything. So, all right. This all has to be a complete system. Now, I also want you to realize, and sometimes attorneys are guilty of looking at it this way, this isn't selling documents. The documents are just tools that are part of putting together the whole overall strategy. So the documents aren't the plan. The way it's set up, the different provisions, how your assets are going to work and coordinate with this overall plan, it's a full estate plan. The documents are only a part of it. So you don't want to try to, well, I can download and do my own healthcare power. No, look, it all has to work and fit together. Now, I end up with this question a lot because I have people who watch the YouTube channel and who are getting on the courses who are out of state. Well, Jeff, can you do this for me? Well, no. As an attorney, I'm only licensed in North Carolina. Other things like Medicaid planning, I can do that across all 50 states. It's just often there's some legal component and we need an attorney who can handle that. Life insurance, annuities, or other financial things. Yeah, I can do that. It's very easy to transfer a license and get in there. But look, if you're talking about your overall estate plan, we need an attorney in that particular state. Even if I'm being brought on as a consultant, and sometimes I am, for just the general estate planning using a revocable living trust, fine, but there needs to be another attorney. I'm part of a network I already mentioned in the modules, the Estate Planning Source. You can contact them directly, or my law office is happy to give you the number, or potentially even specific attorneys in specific states that we've worked with. I know that they can put together the same type of plan that I'm describing here without an issue. So if you are looking into getting this done in your particular case, there's a way to do it even if you're not residing or have a big contact with North Carolina. I'm not going to be the attorney to specifically help, but again, I can consult on cases. All right, so I hope you found that general overview of help. Now, in the next modules, we're going to get into specifically the asset management trusts and the IRA trusts. And again, check the bonus materials for some of the stuff from the estate crash course so that you can get a little more detail on some of the things with the revocable trust and the ancillary documents. We'll see you in the next module.